Now, Miss Brooks, it's been drawn to my attention over the short adjournment that it's rather cold in court.
Oh, it is. It's freezing.
I say it's been drawn to my attention. We'll leave it there, actually, as to who drew it to my attention. Suffice it to say, the point was made very forcefully. I could press. I think this may.
I'm not sure they work.
I have the temperature controls, but I gather they're not working.
I've tried, my lord, and I've also emailed accommodation again, so
Thank you.
I haven't got a response back from them yet.
I'm going to have to go to the ultimate arbiter. Can you do anything about this?
My lord, of course.
Okay, Mr. Williams will have it in hand. Anyway, it's very cold. I'm very sorry. I'm very sorry. I hope that everybody's managed to make arrangements to cover what needs to be covered. And what has happened, if anything, over the short adjournment? Anything further to
Yeah, so I
pass on?
spoke with the Guardian,
Yeah.
and I think it will be obvious from all that the Guardian said at the hearing that the ideal situation for this child would be in a position of permanence with this family. And so if that could be achieved, and of course I need to make it very clear that in the hearing below, the Guardian was clear that couldn't be achieved. If, as it now appears, there seems to be a willingness on the part of the foster carers to adopt a more flexible approach to certain aspects of the support that they would be given as adopters, then she thinks that is wonderful news.
I should say, Miss Brooks, that in addition to a hard copy of the email which you read out, we've also received the position statements, I think, from Miss Davis. Thank you very much. Did you get? I forgot to ask you. Did you get those?
No.
Who did you send them to? Mr. Williams.
To Miss Charan and Mr. Williams.
Yeah, it hasn't
Okay. Well, I'm sorry. Should have checked that. I've printed. Thank you. We got all 4 case summaries, position statements. There's not. I don't think it's going to matter too much at the meeting. But I've got your. I had printed off the Guardian's position statement, so not yours, of course, your predecessors, your solicitors.
Well, I haven't
and
had a chance to see that. I know it was sent to me, but
I mentioned it because it makes the point. The point that you've just made is it's been her position all the way through. So, right. So, what do you say about what submissions do you now make?
well, at the moment, the local authority have a placement order. It's a permissive order. They will consider any candidates who wish to adopt this child. And the Guardian would say that in the hierarchy of those who are available, without, of course, knowing anything about other candidates, she would suggest to the local authority that the obvious outcome is to work with the current carers with a view to them adopting this child.
So, you say on that basis the appeal should be dismissed and leave it to the local authority. Is that what you're saying? To decide.
Yes, I should be completely frank, however.
Yes.
And say this, that the Guardian is, of course, somewhat concerned that we know that the local authority has spoken with the carers about adoption because they have a placement order. So, of course, they're going to talk to them about that. And, of course, the adopters are going to respond about that. What we don't know is whether or not that change of approach would have influenced their decisions about special guardianship, for instance.
You mean the D's decisions? Or and fostering?
And fostering, but I need to make it very clear that the Guardian had a number of concerns about
The merits of fostering generally. Yes.
Now, the Lordships will know that the financial package is not the only issue that there's been in this case, and there's been some conflict about areas such as contact and so on, and some conflict about the care that the carers have been giving not expressed by any professionals, but by the family. And one of the concerns, certainly the Guardian recalls, that these carers had about a special guardianship order was the proximate nature that would then put them in as far as the parents and wider family is concerned. They were concerned about that. They were concerned about the lack of, and I think this is clear from the evidence that has already been filed. I'm not giving evidence on this. They were concerned about the lack of security for them in terms of permanence because of the ability of family members to apply to discharge. I'll put it no higher than that.
Yes.
So the Guardian isn't suggesting that her contention would be that the option which would best meet the needs of this child would be special guardianship. She's not saying that. But she is saying that she's mindful that these carers haven't been asked what their views would be about that. I'm putting it very inelegantly. So on the basis of the information she has at the moment, she would say dismiss the appeal.
The alternative is to allow the appeal and have a rehearing at which all options can be reviewed, the realistic ones, clearly identified, and the advantages and disadvantages of each thoroughly investigated. In fairness to everybody, it's quite clear, at least to me, that this is a very complicated, even by the standards of this type of case, it's a very complicated picture because the strength of the D's relationship with the child and the positives about the placement are another dimension which has to be added into the analysis.
They do, and whereas it seemed to be clear at the hearing below that it wasn't realistic. So the only way of maintaining a placement with the D's was by a rigidity of the financial package. It's not realistic. That rigidity or that degree of inflexibility appears, certainly as far as adoption is concerned in any event, to have moved on.
Yes.
One of my last comments before lunch was I can feel the Guardian pulling her hair out, and of course the Guardian says, you know, we spoke about all of this last year.
Yeah, well, I've read the reports, I've read her evidence again, and I've got your predecessor's position statement. Yes.
My lord, just to add that I emailed
Yes.
the D's at 1:13, and I texted Mr. D straight away to say I've emailed you with this question, and I called him just before we were coming back into court to say no pressure, but we're back at 2, and he said he's dealing with some Play-Doh and then he will respond to the email, and I did say that we do need an answer. But he hasn't yet responded back. He does know that we are back in court at 2:00. I did also say the court is emphasising he should not feel under pressure.
Yeah, well,
It's
Play-Doh is, dealing with Play-Doh is extremely important.
Indeed. So I don't know that we're going to have a fully considered view by the Ds as a unit, and we, in consultation with them having had the opportunity to discuss this with their supervising social worker as well as the relevant teams.
No, I entirely agree.
So it may be that that is a matter that can be an ongoing direction by the court for the local authority to continue to investigate as an indication, whichever way the decision goes in terms of what happens with the appeal.
Well, yes. If we dismiss the appeal, and the local authority will move forward with its placement order, and will evaluate the D's position as prospective adopters along with the other candidates you've got.
Indeed. And if it is an indication, that is one of the things that the team manager of the family finding team did respond to, is in that lengthy list of questions that that was before the court below. The question of would they be given any precedence over any other prospective adopters was answered by the team manager of the family finding team to say, obviously, in the absence of an assessment, it's difficult to be definitive, but the opinion of the team manager was that they would be considered favourably because they've had the care of the child, proven track record of the care of the child, and the proven... And
moving the child from this...
Yes.
Moving this child is particularly fraught with danger.
Absolutely. So
yes.
It's not... And I would just add one last time that I know that a lot has been said by others about the difficulties with the financial package, but actually the local authorities' case has always been that there are advantages and disadvantages to all legal frameworks. And with long-term foster care, the disadvantages, the welfare-based disadvantages, have perhaps been understated in the judgment, but were at the forefront of the judge's mind.
Thank you very much. So, Ms. Fairclough, what do you want to say in reply?
My Lord, just to touch briefly on the issues that have arisen today in respect of Mr. and Mrs. D. My Lord, there is still significant uncertainty, of course, in respect of that position, and in my submission they would need legal advice, need more than simply a phone call today to be able to provide an answer. Furthermore, my Lords and my Lady, in my submission, it does raise open those various other options that the court had previously considered in respect of potentially special guardianship order and the option of long-term foster care, which in my submission is one that was open to Her Honour at the court below. In any event, my Lord heard submissions in respect of the funding for long-term foster care. And I simply wanted to clarify that it is clear from the questions asked at B57 that the fostering allowance is not a means-tested allowance, so different to special guardianship orders and the adoption support plan. Question 3 specifically says, is there a means test to the fostering allowance and how is this carried out? And that clarifies that fostering allowance is not means tested. And my Lord, in my submission, very different situation for the funding of long-term foster care to the funding arrangements for a special guardianship order and adoption order, because of course Mr. and Mrs. D are with a fostering agency with whom the negotiations in respect of funding take place. Those questions further clarify that certainly as far as in-house, and the local authority couldn't answer on behalf of the agency, but in-house the allowance the same for short-term and long-term foster carers. So no difference in that Mr. and Mrs. D are receiving now to they would be continuing to receive. In respect of the Guardian's position, I would, my Lords and my Lady, highlight the evidence that the Guardian gave at the hearing. It's at A92.
Yes.
Within the summary of her evidence, and she had said this when asked a question by the judge. I cannot support that as a primary care plan, talking of long-term foster care, if we could keep her with the Divines and keep contact, with the Ds, and keep contact with everyone, that is best. Not the care plan, that's not the care plan, and not one I have say or influence over. That is what I believe would be right for her.
Okay, well, let me just, the question.
The question
It's not a question, it's not a question.
No.
I cannot support, what can't she support as a primary care plan?
I think I
It was
know
in
the
relation to the to long-term foster care.
What? Any long-term foster care or long-term foster care with strangers?
Well, the Guardians, the reference to
I don't understand the question. The either part of that exchange, I'm afraid. Do you?
Well, I read it as being the judge asking, what do you make of the local authority's evidence that without a commitment to leave her with the Ds, it's not satisfactory to have long-term foster care. And the Guardian saying, I can't accept that as a primary, i.e. long-term foster care, not specified.
not specified as a care plan, but went on to say, and the key point I say is that she said this, if we could keep her with the Ds and keep contact with everyone, that is best, and that was the position that she was advancing at the final hearing. And I raised that, of course, that's relevant given the way in which her case had advanced today in respect of a plan of permanence through adoption, which differs slightly from that evidence that she had given at the final hearing in relation to the ongoing contact. In my submission, the issues that have arisen today in respect to Mr. and Mrs. D's position don't affect the grounds of appeal that I have advanced, save, of course, for the ground in respect of prospects of identifying an adoptive placement. They make no change to the lack of analysis, no difference to the lack of analysis, my lords and my lady. They make and don't change the fact in my submission that there was no proper analysis of long-term foster care with Mr. and Mrs. D as an option which in my submission was a realistic option before the court. Can I assist my lords and my lady any further?
My lady observed out of the corner of her eye that Miss Brooks wasn't agreeing with something that you were saying. I'd like to clarify what that. Miss Brooks, do you want to clarify what that was?
Yeah, I think the problem that I have is really with the quality of the notes taken, of the evidence and the exchanges, really.
Well,
In parts they flow better than others. In other parts, it literally makes no sense at all what's being asked.
Yes.
These are notes which have been approved, not by the judge, but by the advocates
they're not.
intended.
No, they're not approved. Then they're agreed, but not
Agreed,
approved.
sorry, they've been agreed
Yeah.
by the advocates
Okay.
intended. And so I would just caution any reliance on what is an incomplete note of the evidence.
Thank you.
Just on that point, just to add that even the Guardian, definitely the social worker, but even the Guardian raised concerns about what would happen with contact going forward,
Yes,
and the ongoing issues. So it may be right that in an ideal world she might have wanted there to be contact, but she was realistic that there was going to be difficulty with that, and we already know that that would have been the D's position if there had been an SGO.
Right. Anything else you?
I've just circulated the
Just a moment.
response.
Sorry. Yes, Miss.
Yes, I received a response from Mr. D, which I've circulated and I've sent to Ms. Johan and Mr. Williams. And the long and the short answer is I don't think they've answered the question.
Well, I the more I've been thinking about this, the more I'm reluctant to get involved with it. It's not fair. Mr. D, the law prevents them being part of these proceedings.
Yes.
I think we've heard enough to realise these are very delicate and difficult matters, and we don't want to anything to be said that in haste would be less than helpful, I think. But we're very grateful to Mr. D, and we'll look at it, obviously, but I don't think you need forward it to us. We don't need anything further about that at the moment. I would like to know everybody's views on the point I raised before the short adjournment. If, and I stress, if we were to allow the appeal, what do you say would have to be a rehearing? What do you say should happen? Back to the same judge or to another judge?
My view, I don't know whether I'm going out of turn, but as I'm standing, I might as well address the court first, is I think Judge Gargan has had unarguably the most judicial contact with this case than anybody else. She knows this case very well, and in my submission she would be best placed to weigh up the differences in opinions and where people have got to, and also the realistic likelihood of a placement succeeding, having had the advantage of lengthy involvement with the case and having heard extensive evidence.
Thank you. Does anybody disagree with that?
Well, not so much a disagreement. I would entirely agree with my learned friend that Her Honour Judge Gargan has a very firm grasp on the facts of this case and, of course, on Elle's needs. The anxiety I raise in respect of it being, if the appeal was successful and it were reheard by Her Honour Judge Gargan, is the decision, of course, that has already been made, and then the remaking of the same decision, essentially undertaking that analysis afresh without without being influenced by the decision or obtaining that decision she's already made. So
Thank you.
I put it no more
Anybody-
strongly than that.
Thank you. Anybody else want to say anything else?
Echo what Miss Fairclough said.
Okay. Right. Thank you. Anything else? No, sorry, we should just. I think we'll just rise for a moment just to take stock.
Sorry. Sorry, it's literally
Is it that one?
Yeah,
Is it that camera
literally.
there? Or that
I think
camera
I heard it like as I was just walking past the shop.
Which camera is it? Do you
Let
know?
it take root.
No.
It is definitely warmer here now. It's nice.
For your sake.
Yeah. Oh my God, can I? Thank you. It's switched it off.
Yeah, sure.
Ah. After a while, I have to do something else. It's like, oh. This piece of work myself, 38,500 words. It's quite a lot, isn't it? School thing, university. I know some of the words at Cardiff, never heard of it. Garbage.
Well, thank you very much for your submissions in this case. This is a very difficult case, and we're going to reserve our judgment and think carefully about the issues which are not straightforward. We're very conscious, of course, that it's a child case and you'll want a decision as quickly as possible. All I can say is we will do our best, and I would hope, without committing myself, well, I hope we'll get it out this term, before the end of July. So what will happen is you'll get a judgment in draft, judgments in draft from us. That will be for you to correct any minor factual errors or typographical mistakes. Not an opportunity to re-argue the case. We won't ask for any further information. We'll decide the case on the basis of what we've got already. So please no further submissions in response. But we'd like your typographical comments back, and then in due course the judgment will be handed down. Under the new scheme, there's no need for anybody to attend. It'll be handed down remotely on the fixed day. Please bear in mind the warning at the top of the draft judgment when you get it in draft. It is confidential and not to be disclosed. Following recent cases, it's important that you comply with that embargo.
Would the court give permission for the judgment to be disclosed with the Ds?
Well, the draft judgment.
Not the draft judgment.
The
The
judgment will be
yes,
will be published anonymously.
Yes.
And so of course it can be disclosed to the Ds. Thank you very much.
Right.
So just a little thing on that.